You're on live. All right. Good evening, everybody.
Good evening, sir.
You are almost there, and we are even doing this in online streaming also in YouTube. Okay. I will share the link in the chat box as earlier. All right. Here we go. So, good evening. Welcome to all of you. Today's topic is art of cross-examination in criminal matters. Here, before we go into the cross-examination, there are certain basic aspects in criminal law which you have to make a note of and understand it properly. First and foremost is what is the exact definition of the word crime? Crime has been defined as an offence committed by committed punishable under the Indian Penal Code. Then, how an offence is defined? An offence is defined as an act which has been done, which is punishable under the penal laws of the country. The third one is what is the basis of of uh, finding out whether a crime is committed or not. Here it is said, and the answer to that would be by proper investigation and interrogation. Then the question arises: who can lodge a complaint, lodge an FIR under Section 154 CRPC? It is not only the victim, but any bystander or a neighbor also can lodge an FIR. It is called the first information report. Then the next question arises: before whom the FIR has to be who has to register the FIR? The FIR will be registered by the police, the concerned police station, who records the FIR. The FIR is recorded by the station house officer. Why I'm saying station house officer is the officer or the constable or the head constable who is on duty on that particular day at that particular time records in writing the FIR and registers the FIR. Then next one is what is meant by investigation. Investigation is that means where a complaint is lodged, and based on the complaint, the police officer commences his work, going to the spot, examining the accused, and trying to find out whether the crime has been committed and under what circumstances it has been committed. Then what is meant by general diary? This is most important in criminal law. It is popularly called the GD. That is the register that is kept and maintained in every police station, which contains the entire crux of the complaint that has been lodged by the complainant before the concerned police officer. Then what else is required? Contents of an FIR is the date of offense, place of offense, time of offense, the name of the complainant who has lodged the complaint, name of the person who has been charged with the particular offense, and the jurisdiction of the police station which receives the FIR. And then the complaint, in short, is recorded in the FIR and also entered in the GD, or what is called the general diary. Then, as far as a complaint is concerned, can it be given orally or should be given in writing? It is preferable that it is given in writing, because tomorrow you can always urge before the court, sir, a complaint has been given in writing, but no action has been taken. Then the next question arises: if the police officer does not register the complaint, then what is the procedure, or does not prepare the FIR? Then in that case, you can knock at the doors of the High Court and file a writ petition under Article 226 or 227 ask the High Court to give directions to the police officer to register the FIR. Then the question is, who is a station house officer? I told you already that a station house officer is the person who on duty on that particular day at that particular time who receives the complaint. Then what is meant by 161 and 162 statements in CRPC? 161 and 162 statements are the statements given by the complainant before the police concerned, or the witnesses who appear for and on behalf of the complainant and whose statements are recorded by a police officer. It is called 161 and 162 statements. One important thing you must remember is 161 and 162 statements should not be signed by the witness. If it is signed, it is not admissible in court. This is a basic thing you must remember. Always it is said that whenever statements are recorded, it must come from the horse's mouth, not through someone's mouth. That is, your advocate who appears for the complainant comes and gives a statement. It cannot be a 161 statement. It's a tutored statement that is given. That is normally not taken into consideration by the court. I still remember, I can give you one example. In one case, 9 persons were accused of what is called 498A and DP Act, that is Dowry Prohibition Act, under 4 and 6 of the Dowry Prohibition Act. I was the person who appeared for the accused, all the 9 accused, and I told when the witness was in the witness box, I asked the IO as to who recorded the statement. She said, I recorded the statement. Then I asked her a question, sir, madam, did you record it in writing or you recorded it orally? She simply said, sir, the witness did not appear before me, but her advocate dictated the statement and I typed it on my typewriter. Please remember, such type of statements are absolutely irrelevant and inadmissible. They cannot be taken into consideration. Then we come across 164 statements. Please remember, 164 statement is a statement which is recorded by the magistrate, and it is more credible and trustworthy for the simple reason that the person whose statement is recorded by the magistrate he is given some time to ponder over and give a statement, and he is also forewarned you are not under a compulsion to speak, but if you speak, this version is going to be used against you. Here, as far as the difference between 161 statement and 164 statement is, they, as far as, yes, sir, as far as the accused is concerned, is not given time at all to think about. But 164 statement is, it's a statement which is given by the witness before a magistrate who gives time to the witness to depose and to give a statement, and also forewarns the witness saying that you are not under a duty to speak, and if you are going to speak, it is going to be used against you. Please unmute it, please. So the question is, 164 statement is more credit-worthy than 161 statement. I'll tell you why 161 statements. Sometimes what happens is, when we give a statement before the police, yes, sir. When we give a statement before the police, we are scared. We are scared and we are under a fear psychosis. You need not have any fear. But if you are before a magistrate, the magistrate says, please answer in a cool and calm atmosphere. Don't get perturbed, don't get agitated. Take your own time in giving a statement. And he also says, the magistrate also says, in case you make a statement which is incriminatory, you'll have to face the consequences. That's the reason why 164 statement is more preferable than a statement under 161. But the latest theory in criminal jurisprudence is your advocate also can be present at the time when the statement is given, because he trains you properly as to what you have to say. But he cannot open his mouth and tutor the witness right in the presence of the police officer. Then, what is meant by inquiry? Please remember, inquiry has 2 spellings. One is ENQUIRY and another is what is called inquiry. That is INQUIRY. What do you mean by inquiry? Inquiry means when the police
స్వీట్స్ మేకింగ్ కి అవి కడాయిలు కావాలంటే తీసుకురావచ్చు.
Sir, please unmute it, please. It is disturbing the lecture.
ఎక్కడ
Swati.
స్వాతి గారు ఎవరండి?
Swati garu, please unmute your mic, please.
Yes.
What is meant by inquiry? Inquiry is when the police calls the witnesses before him, records the 161 statements, takes up investigation, records the statements, and that is called inquiry, not enquiry. Enquiry is trying to find out the truth. But inquiry means what statements are recorded by the police officer during investigation. It is called inquiry. Then we come to what is called the statements. What is meant by
ఎంక్వైరీ. ఈ ఎంక్వైరీ.
inquiry? Inquiry. INQUIRY. Then what is meant by charge sheet? Charge sheet is one after investigation is over, inquiry is over, the statements are filed into court, and the statements are gone into the various offences that has been committed by the accused under various sections of the Indian Penal Code. He is charged with those particular offences, and they are mentioned in a document called charge sheet. And what are contained in the charge sheet is sum and substance of the complaint, the witness, what has been elicited from the witnesses in the 161 and 162 statement or 164 statement, how the offense is made out, so on and so forth. And along with that, in the annexure, the list of witnesses are also given who are going to be examined and what is the scope of their evidence, and their names and their addresses are also mentioned. Then along with that, the police also files the incriminating documents which charges the accused of that particular offense. Please remember, here itself I make it very, very clear that the trial which is going to be conducted in the court should be a fair and transparent trial, and principles of natural justice.
Recording in progress.
Principles of natural justice has to be followed. And the accused is entitled to get all the paramateria that has been filed by the prosecution before the court, before the trials, when the trial starts. And under section 205 CRPC, let us say some of the documents are not furnished. Always you can file a petition before the court under 205 CRPC. Sir, I have not been given the documents. Kindly direct the prosecution to furnish those documents. Then a question arises. Sometimes your client may lose confidence in the public prosecutor. He says, sir, why don't you assist the public prosecutor in conducting the prosecution? There is a provision for that, to saying that it is 302 CRPC, which says you can always file a petition that you want to assist the prosecution. You cannot conduct the trial, but the prosecutor is guided by a guidance given by your advocate who guides the prosecutor. Automatically, 302 petitions are not rejected. It is normally allowed. But as you as an advocate, you cannot conduct the prosecution, but you can assist and you can also advise the prosecutor on behalf of your client as to how the case has to be proceeded with. Then on what basis charge sheet is prepared? Charge sheet is prepared based on 161, 162 statements and also 164 statements and the ingredients of the offense with which the accused or the delinquent is charged with. Then charge sheet is also based on the investigation. It is also based on the interrogation. It's also based on so many other factors. Then we go to once charge sheet is filed into the court, charges are framed by the judge. And once charges are framed, preliminary arguments also takes place, where the advocate for the accused is given an opportunity of of trying to explain the charges and also explain as to how the charge is not made out. Then, if the advocate succeeds in satisfying the court that the ingredients of the offense is not satisfied, charges will be dropped. There will be no trial at all. Suppose, let us say, in spite of advancing arguments against framing of charges, the court rejects it. You can always go to the High Court under the CRPC and file petition before the High Court saying that the lower court had wrongly rejected your application before framing the charges. Your arguments were not properly heard, properly appreciated, and the court has committed a mistake. Then sometimes there is also a provision in the CRPC saying that if an FIR has been lodged which is absolutely ridiculous, then in that case you can always file a quash petition before the High Court, concerned High Court, to quash the charges, saying that the offence is not made out. Then, even when the crime is registered, you can always question the crime and also the FIR that has been registered. Ask the High Court to quash the FIR that has been framed against you. Suppose, let us say, in the High Court you don't succeed, then you have got an opportunity of going to the Supreme Court and questioning the verdict of the High Court. Then suppose, let us say, you lodge a complaint. The police does not register the FIR nor files a charge sheet with the court. Then you have got provisions called 192 and 200 CRPC, which says you can always file a private complaint before the concerned magistrate, and the magistrate records the records the your statement, or what is called sworn statement. And then if you find that there are merits in your criminal case that you have filed, it refers the matter to the police under section 157 for investigation. Then once the magistrate refers the matter to the police under 157, it's the duty of the police officer to investigate under 172 and 173 CRPC, and then under 174 CRPC he has to file an IR, or what is called investigation report, before the court. Then suppose, let us say, the case is not, the police officer gives a statement, gives a report saying that, please unmute. So suppose the police gives a report saying that a matter is of civil nature, cognizance cannot be taken. Then in that case, you can always file a petition under 202 CRPC for what is called as protest petition, and ask the court to listen to it. And the court finds that the police has not done the investigation properly, it again refers the matter back again to the police for re-investigation. Then we go to what is meant by cognizable and non-cognizable offences. Cognizable offence means where a police officer can arrest even without a warrant. Non-cognizable offence means where the police officer cannot arrest without a warrant issued by the proper magistrate. Then, when can a police officer arrest without warrant? Whenever a cognizable case takes place, a capital offence takes place, a murder takes place, kidnapping takes place. In that case, suppose the assailant is found, even without a warrant, he can be arrested. But what are the precautions that have to be taken by the police officer is, however grave the offence may be, within 24 hours, the delinquent has to be produced before the nearest magistrate. And once he is produced before the nearest magistrate, within 24 hours, the magistrate remands the accused. And first time, he remands the accused for 14 days for judicial custody. That is subject to his supervision. He will be kept in custody by the police. And then investigation takes place. The maximum period for which the remand can be granted by the court is 90 days. Beyond 90 days, the court cannot extend the remand. But the first instance, the remand is given for 14 days. After that, at the instance of the police, it is extended from time to time to a maximum period of 90 days and not beyond 90 days. Then the question arises, sir, if suppose it's a very grave offense, a capital offense that has been committed, can the court grant bail immediately? No. Court orders for notice to the prosecution. Prosecution will be given an opportunity of opposing the bail petition by filing the counter. Only when the arguments are heard on both sides, the court comes to a particular conclusion. And before 90 days, normally in capital offenses, courts do not grant bail. It is very, very difficult to get bail where it is a capital offense. Like in some enactments, like what is called the sexual offenses, then murder, culpable homicide amounting to murder or not amounting to murder, kidnapping and abduction, misappropriation, breach of trust. Then you have got what is called so many other things are there. Are offences under the PMLA Act, that is the Prevention of Money Laundering Act. Then you've got the COFEPOSA, that is the Conservation of Foreign Exchange and Prevention of Smuggling Act, so on and so forth. All these capital offences are the violations which are complained of by the ED or the CBI. Normally, before 90 days, no bail is granted. As many bail petitions you file, court will not grant you bail. Why? Because for 90 days, it gives the police a right of investigating the matter further. Then what are the precautions the court takes while granting bail? Bail is normally granted under 436, 437, and 438 of CRPC when it's a bailable offense, non-bailable offense, and anticipatory bail. I'll come to anticipatory bail first. When a person apprehends arrest in a crime which he has committed or has not committed, then in that case he can go to the sessions court and say, sir, I've got every apprehension that I may be arrested by the police at any time. Please grant me anticipatory bail. I am prepared to abide by any terms and conditions that are imposed by the court. Please try to grant anticipatory bail. Then in that case also, the court issues notice to the prosecutor. Prosecutor is given the right to file a counter, oppose the bail petition. Under what circumstances a bail petition can be opposed? One is the witness is a very influential person. He is likely to abscond from the jurisdiction of the court. Third one is he will try to tamper with the witnesses who are going to come and give evidence against him. Under those circumstances, the court does not grant bail. But suppose anticipatory bail is given, it doesn't mean that you will be released immediately. You have to surrender before the lower court, and the lower court tries to release you on bail subject to certain conditions, that every Sunday or every Saturday you have to attend the police station, you have to be available for investigation, you shall not tamper with the witnesses, you shall not commit any act which tries to impair the investigation process, and all these things. Then the conditions can be imposed by the magistrate, and money bonds, surety bonds are taken where it ensures the attendance or presence of the accused in court on the days which are fixed. Then, of course, the CRPC has undergone an amendment also. There is a provision called Section 41A, which says in all cases the accused need not be produced before the court. The police officer concerned, especially when it's a bailable offense, he can grant station bail. Bail bonds can be taken, and the accused can be bound over and be present in the court on the date when it is fixed. Then what is the procedure that is followed in courts when the accused is presented? The accused is first examined whether he is guilty or not guilty, and that statement will be recorded by the magistrate concerned. If he pleads guilty, then whatever punishment is given under that particular section, that punishment will be imposed. Normally, the accused is let off with a fine amount. But suppose the offense is punishable with a graver offense, rather, normally in that case, the trial proceeds. But suppose the accused says, I am not guilty, sir, I have not committed any offense. Police has unnecessarily framed me in this particular case and implicated me out of rivalry. Then in that case, the accused is given an opportunity of fighting the case. Then in that case, the court takes what is called bail bonds. That is, normally personal bond is taken, and also a surety bond also is taken. Surety bond is also taken, whereby the surety ensures the attendance of the witness, the accused, on every date of hearing. Then please remember the CRPC also has been amended in cases where the accused absconds from the jurisdiction of the court and is not found. Normally, NBW is issued. That is what is called non-bailable warrant, and the police is directed to arrest the accused and bring him to the court and produce him before the court. And notice is also issued to the surety to produce the accused in court. Please remember, if the surety fails to produce the accused in court for repeated adjournments, the surety bond which is given by him for that particular amount, and he will be imprisoned for 6 months till the accused appears in court. And the next procedure is that even the accused absconds, a proclamation is made whereby it is said, whoever finds the accused, please hand him out to the police station. Or then in that case, he'll be named as proclaimed offender. His property will be attached, his family members will be disturbed, so on and so forth. So these are the repercussions if the accused absconds and does not attend before the court. Then, suppose, let us say, the case is fixed on a particular day and the accused does not appear. Then when he does not appear, court issues what is called a non-bailable warrant, NBW as they call it. And non-bailable warrant is the police is directed to apprehend the accused wherever he is and bring him before the court. And once he is brought before the court, normally, if no petition is filed to recall the NBW, then in that case, he will be sent to prison. But there is a procedure also, you as an advocate should know, there is a procedure called Section 70, Clause 2, which says recall of NBW, recall of non-bailable warrant. Then in that case, if you show sufficient cause why you were not present on that particular day when the case was called, then in that case, the court can always have the power to recall the NBW and prevent you being apprehended under the non-bailable warrant. Yes. Now I come to the vernacular, that is in Telugu. అంటే ఈ నేరాల చట్టం ఏదైతే ఉందో సిఆర్పిసి అనేది, మనం ఎదురు ప్రశ్నలు అడిగే ముందు మన నేరాల చట్టాల కోర్టుల మనం కొన్ని థియరీ తెలుసుకోవాలి. దాంట్లో ఎట్లా అంటే, సపోజ్ ఒక నేరం జరిగినప్పుడు ఆ నేరస్తుని పట్టి వాడిని శిక్షించాలని చెప్పి మనం అడుగుతాం. ఎవరైతే కష్టపడతారో వాళ్ళు అడుగుతారు అనమాట. అది వాళ్ళు ఏం చేస్తారంటే, కోర్టులో కంప్లైంట్ పోలీస్ దగ్గర, అంటే పోలీస్ వాళ్ళ దగ్గర ఒక అర్జీ పెడతారనమాట. ఇలా జరిగింది, నన్ను ఇట్లా కొట్టాడు, ఇట్లా చేశాడు, అది చేశాడు, ఇది చేశాడు. దాని మీద చట్టపూర్వకంగా ఏదైతే ఇది చర్యలు తీసుకోవాల్సిందని చెప్పి మీరు కోరుతారు. అప్పుడు అది మీరు ఏదైతే అర్జీ పెడతారో పోలీస్ ముందు, అది వాళ్ళు ఏం చేస్తారంటే దాన్ని తీసుకుంటారు. దాన్ని బాబత్తు ఒక డాక్యుమెంట్ తయారు చేస్తారు అన్నమాట. క్రైమ్ అని ఒకటి, నేరం అనేది ఒకటి పెడతారు, దానికి ఒక నంబర్ ఇస్తారు, దానికి ఒక ఏ సంవత్సరంలో వేస్తారో అది వేస్తారు. తర్వాత ఏ తారీఖున నేరం జరిగింది, ఎక్కడ జరిగింది, ఏ టైంకి ఏ సమయంలో జరిగింది, నేరస్తుడు ఎవడు, ఇది అర్జీ పెట్టినోడు ఎవడు, అర్జీ పెట్టిన మగవాడి ఏది అంటే వాడి అడ్రస్ ఏది, ముద్దాయిది అడ్రస్ ఏంటి, ఆ కంప్లైంట్ అర్జీలో ఏమేమి చెప్పాడు అదంతా ఎఫ్ఐఆర్లో రాస్తారనమాట. అప్పుడు దాని తర్వాత ఎఫ్ఐఆర్ రిజిస్టర్ అయినాక ఫస్ట్ ఇన్ఫర్మేషన్ రిపోర్ట్ అంటారు. అంటే మొదటిసారి పోలీస్కి మనం అర్జీ పెట్టినట్టు. అర్జీ పెట్టేది మీరు పెట్టాలా లేకపోతే వేరెవరైనా పెట్టచ్చు అంటే, నేరం చేసినప్పుడు మీరు కానీ మీ పక్కన ఉండే నైబర్ కానీ ఎవరు కానీ వాళ్ళు కూడా కంప్లైంట్ ఇవ్వచ్చు, అంటే అర్జీ పెట్టచ్చు. మీరు ఎవరికైతే నష్టం జరిగిందో వాడి ఇవ్వాలని లేదు. అప్పుడు వాడు ఇచ్చిన తర్వాత పోలీస్ శాఖ వాడు ఏం చేస్తారంటే దాన్ని దర్యాప్తు మొదలెడతారు అనమాట. ఎక్కడైతే ముద్దాయి ఉన్నాడో వాడిని పోయి అడుగుతారు అనమాట, నువ్వు ఈ నేరం చేసావా లేదు, ఎందుకు ఇది చేసావు, ఏ సమయంలో చేసావు, ఎందుకు చేసావు, వానికి ఎందుకు కష్టపెడుతున్నావు, అదంతా అడుగుతారు అనమాట. అడిగిన తర్వాత సపోజ్ వాడు నేరం చేసి చాలా ఘోరమైన నేరం ఉంటే వాడిని 24 గంటల లోపల ఏదైతే మ్యాజిస్ట్రేట్ న్యాయమూర్తి గారు ఉన్నారో ఆ ఇలాకాలో ఉన్న మ్యాజిస్ట్రేట్ ముందు హాజరు పెడతారు అన్నమాట, తీసుకొస్తారు. అప్పుడు జడ్జి గారు ఏం చేస్తారంటే, బాబు నువ్వు నేరం చేసావా నేరం చేయలేదా అని. వీడు నేరం చేశాడని చెప్తే వాడి ఫైన్ కింద వాడికి ఫైన్ వేసేసి వాడిని వదిలేస్తారు. వాడు నేరం చేయలేదని చెప్పి, సార్ నాకు అనవసరం పోలీసు వాళ్ళు నా మీద చర్యలు తీసుకుంటారు సార్, పోలీసు వాళ్ళని ఆపాలని చెప్పి మీరు అంటారు. అప్పుడు న్యాయమూర్తి గారు ఏమంటారంటే, సరే ఈ ఫిక్స్ ఆయన డేట్ ఫిక్స్ చేస్తారు అనమాట, ఈ డేట్లో దీని కేసు నడుస్తుందని చెప్పి. కానీ దాంట్లో రెండు మూడు టైప్స్ ఆఫ్ అఫెన్సెస్ ఉంది. వన్ ఈస్ బెయిలబుల్ అంటారు. బెయిలబుల్ అంటే బెయిలబుల్ మిమ్మల్ని కోర్టులో హాజరు పెట్టనక్కర్లా, మిమ్మల్ని పోలీస్ స్టేషన్లో పిలుస్తారు అనమాట. ఎందుకు నీ మీద చర్యలు తీసుకోకూడదు, నువ్వు ఎందుకు ఈ నేరం చేసావు అని పోలీస్ ఆఫీసర్ అంటే ఇది ఇన్స్పెక్టర్ గారు అడుగుతారు అనమాట. అప్పుడు మీ సంజాయిషి మీరు ఇచ్చిన తర్వాత మీకు మీకు కోర్టులో ప్రతి ఒక్క రోజు మీరు హాజరు కావాలని చెప్పి మీకు వాళ్ళు స్పష్టంగా చెప్తారు అనమాట. ఏ రోజైతే కోర్టులో ఇది న్యాయస్థానంలో మిమ్మల్ని ఉండమని చెప్తారో ఆ రోజు మీరు న్యాయస్థానానికి పోవాలి. అప్పుడు మీరు బెయిల్ పెట్టి న్యాయస్థానానికి పోయేసి మీరు అక్కడ బెయిల్ బాండ్ అంటే ఎవరు మీకు జామీన్ ఉండాలన్నమాట. ఆయన అంటే ప్రతి వాయిదాకు ఈయన కోర్టులో హాజరవుతారు, ఆయన కాకపోతే నేను దానికి బాధ్యతని చెప్పి వాడు బాధ్యత తీసుకుంటాడు. 10,000 20,000 వాడు కోర్టులో జమ చేస్తాడు, ఫిక్స్డ్ డిపాజిట్. అట్లా ఈ ముద్దాయి కోర్టులో హాజరు కాకపోతే, కోర్టుకు రాకపోతే కోర్టు ఏం చేస్తారంటే ఎన్బిడబ్ల్యూ అని ఒకటి ఇష్యూ చేస్తారు. అంటే నాన్ బెయిలబుల్ వారెంట్. అంటే పోలీస్ వాళ్ళకి ఇమ్మీడియట్ ఆర్డర్ ఇస్తారనమాట. నువ్వు వాడు ఎక్కడ ఉన్నా కూడా వాడిని పట్టుకొని వచ్చి నా ముందు మీరు హాజరు పెట్టాలని చెప్పి పోలీసు వాళ్ళకు ఆదేశం ఇస్తారు. పోలీసు వాళ్ళు ఏం చేస్తారంటే ఎక్కడైతే ముద్దాయి ఉంటాడో వాడిని ఎక్కడ ఉన్నా వాడిని పట్టుకొని వచ్చి కోర్టు ముందు ఉంచుతారనమాట. అప్పుడు కోర్టు ఏం చేస్తారంటే వాడిని రిమాండ్ చేస్తారు. రిమాండ్ అంటే వాడిని జైలుకి పంపిస్తారు ఒక 14 రోజులు. ఈ 14 రోజులు అనేది 14 రోజులని కాదు, ఎప్పుడైతే ప్రాసిక్యూషన్ పోలీసు వాళ్ళు అంటారో సార్ ఈయన 14 రోజులు మేము ఇన్వెస్టిగేషన్ కంప్లీట్ చేయలేము, దర్యాప్తు చేయలేము, నాకు ఇంకా టైం కావాలంటే 90 రోజుల వరకు దాన్ని పొడిగిస్తారనమాట. దాని 90 రోజుల పైన కోర్టుకి పొడిగించేదానికి అవకాశం లేదు. కానీ ఒక్కటి ఎప్పుడైతే ఇది చాలా పెద్ద నేరాలు ఉందన్నమాట, అంటే మానభంగాలు, తర్వాత ఇది హత్య, తర్వాత అపహరణ, ఇదంతా చేసినప్పుడు అవి పెద్ద నేరాలు అనమాట. దాంట్లో మాత్రం ఏం చేస్తారంటే కోర్టు చాలా జాగ్రత్తగా ఉంటారు. ప్రాసిక్యూటరు ఎవరైతే పోలీస్ తరఫున వకీలు ఉంటారో ఆయన చెప్తారు, సార్ ఈయనను వదిలేస్తే ఈయన సాక్షులంతా పాడు చేస్తాడు, ఈయన ఎక్కడ పారిపోతాడు, ఈయన బయట పోయి చాలా అపాయం అంటే అప్పుడు కోర్టు నార్మల్లీ బెయిల్ ఇవ్వరు. కానీ బెయిల్ ఇవ్వకపోతే దాని మీద మీరు సెషన్స్ కోర్టుకు పోవచ్చు, అంటే పై కోర్టుకి, అంటే సెషన్ జడ్జి అంటారు, ఆయన దగ్గర మీరు మనువు పెట్టుకోవచ్చు. అప్పుడు సెషన్ జడ్జి ఏం చేస్తారంటే మీ దగ్గర నుంచి బెయిల్ పెద్ద అమౌంట్ పెట్టేసి దీనికి ఇంత షూరిటీ ఇవ్వాలా, మీరు ప్రతి శనివారం ఆదివారం ఇది మన పోలీస్ స్టేషన్లో మీరు వచ్చి హాజరవ్వాలి, సంతకం పెట్టాలా, మీరు ఈ ఊరు వదిలేసి పోకూడదు, మీ పాస్పోర్ట్ కూడా పోలీసు వాళ్ళకి ఇవ్వాలా, పోలీసు వాళ్ళు ఇస్తే అది పోలీసు వాళ్ళు కోర్టు హాజరు పెడతారు, అది కోర్టులోనే ఉంటుంది, ఆ కేసు అయ్యే వరకు అది ఉంటుంది. కానీ ఇంకోటి ఏమంటే నేరం రుజువు అయ్యే వరకు ప్రతి వాడి అమాయకుడే. అప్పుడు దాంట్లో వాళ్ళు ఏం చేస్తారంటే చార్జెస్ అంటారు, ఏ సెక్షన్ పైన ఏ దీని మీద మీరు నేరం చేశారో అది క్లుప్తంగా రాసి దాని మీద ఈ విట్నెస్ ఈ సాక్ష్యం ఏదైతే ఉన్నాడో వాడు ఇలా చెప్పాడు, నువ్వు ఏం తలుచుకున్నావు అంటే నేను నేరం చేయలేదని అది జడ్జి గారు రాసుకుంటారు అన్నమాట. కానీ ఈ చార్జెస్ ఫ్రేమ్ చేసే ముందు కోర్టు ఏం చేస్తారంటే మీ న్యాయమూర్తి న్యాయవాదికి ఒక అవకాశం ఇస్తారన్నమాట. ఈ చార్జెస్ అంతా నిలవదండి, ఈ నేరం నా మీద మా ముద్దాయి మీద మోపబడింది, చెల్లదని చెప్పి ఆయన వాదన వినిపించవచ్చు. అప్పుడు సపోజ్ న్యాయస్థానానికి ఇది నిజంగానే నిజం అంటే చెప్తే అప్పుడు ఆ ఛార్జెస్ డ్రాప్ చేస్తారు, కేసు జరగదు. ఈ ఛార్జెస్ ఏదైతే నేరాన్ని రీజన్స్ ఉందో అది ఫ్రేమ్ చేసే ముందు వకీల్ గారిని అడుగుతారు అనమాట, నువ్వేమైనా వాదన వినిపిస్తావంటే వినిపించవచ్చు. దెన్ దాని తర్వాత ఇది 161 స్టేట్మెంటు 162 స్టేట్మెంటు ఇది పోలీస్ ఆఫీసర్ రికార్డ్ చేస్తారన్నమాట. ఎప్పుడైతే దర్యాప్తు చేస్తాడో అప్పుడు రాసుకుంటాడు అనమాట. అది ఆయన ఎవడైతే సాక్ష్యం ఇస్తున్నాడో వాడు నోటీసే రావాలి, మీ వకీల్ గారు వచ్చి స్టేట్మెంట్ ఇచ్చేదానికి అవకాశం లేదు. కానీ 164 స్టేట్మెంట్ అని ఒకటి ఉంది, అది వచ్చి మ్యాజిస్ట్రేట్ గారు ముందే మీకు చెప్తారనమాట. నువ్వు దీని మీద మీరు సమాధానం ఇచ్చేది అక్కర్లేదు, నువ్వు మొదలు ఆలోచించుకొని సమాధానం ఇవ్వు. సమాధానం అది ఏదైతే నువ్వు సమాధానం నీకు వ్యతిరేకంగా పోతే నీ వ్యతిరేకంగా మేము వాడతాం, అది ఆలోచించుకొని చెప్పండి. అప్పుడు ఎవడైతే స్టేట్మెంట్ ఇస్తున్నాడో, వాక్మూలం ఇస్తున్నాడో వాడు ఆలోచిస్తారనమాట, నేను చెప్పేది కరెక్టా కాదా అని చెప్పి. కానీ ఈ అవకాశం మీకు పోలీస్ వాళ్ళ ముందు మీకు ఈ అవకాశం ఉండదు. కానీ ఇప్పుడు క్రిమినల్ జూరిస్ప్రుడెన్స్ ఏదైతే డెవలప్ అయిందో దాంట్లో ఏమంటే మీ వకీల్ గారు కూడా మీరు స్టేట్మెంట్ ఇచ్చే ముందు మీ వకీల్ గారు ఉండొచ్చు, కానీ మీ వకీల్ గారు పోలీస్ వాళ్ళ ముందు కానీ మ్యాజిస్ట్రేట్ ముందు కానీ ఆయన నోరు తరగకూడదు, ఆయన ఏం స్టేట్మెంట్ ఇవ్వకూడదు. దెన్ ఇంకొకటి ఏమంటే ఈ ఛార్జ్ షీట్ అంటే ఏ నేరం మోపబడింది మీ మీద, ఏ ఏ సాక్షులు ఏమేమి చెప్పారు, వాళ్ళు ఏమేమి చెప్పారు అదంతా మీకు మీ వ్యతిరేకంగా ఉంది, నువ్వు ఏం చెప్తావు అయితే దాని తర్వాత దాని మీద ఏదైతే చట్టం ఉందో, దాని మీద ఏదైతే కేసులో ఉందో మీ వకీల్ గారు వాదనలు చెప్పిన తర్వాత, సార్ ఇది ఒమిషన్స్ ఉంది, ఇదైతే ప్రాసిక్యూషన్ చెప్పిన అయితే పోలీసు వాళ్ళు చెప్పిన దాంట్లో పొరపాట్లు ఉంది, ఈ విట్నెస్ అసలే చూడలేదు సార్, నేరం నా మీద మా ముద్దాయి మీద మోపింది న్యాయం కాదు సార్ అని వాడు చెప్పొచ్చు. కానీ ఎప్పుడైతే సాక్ష్యం అవుతుందో, సాక్ష్యాలు కంప్లీట్ అయిన తర్వాత, ముగించిన తర్వాత 313 స్టేట్మెంట్ అని ఒకటి వస్తుంది అనమాట. దాంట్లో ఏదైతే ఇది సాక్ష్యాలు చెప్పారో ఇది సాక్ష్యాలు చెప్పారు, ఏం చెప్పదలుచుకున్నాం అని ముద్దాయిని అడుగుతాడు అనమాట. ముద్దాయి ప్రతి దానికి సమాధానం ఇస్తారు. తర్వాత నీ 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 పక్క ఎవరైనా సాక్ష్యాలు ఉన్నారని చెప్పి అడుగుతారు. అది కాదు డిఫెన్స్ ఎవిడెన్స్. మీకు ఎప్పుడు అది రైట్ ఉందన్నమాట, మీకు ఎప్పుడు హక్కు ఉంది, మీ సైడ్ నుంచి కూడా మీరు సాక్షులు పెట్టొచ్చు. కోర్టు నేను అనుమతించానని చెప్పేదానికి అవకాశం లేదు. ఎందుకంటే ఎప్పుడైతే నేరాల ఎంక్వైరీ అవుతుందో దానికి మీకు పూర్తి ఆపర్చునిటీ ఇవ్వాలి, పూర్తి ఛాన్స్ ఇవ్వాలి, మీకు పూర్తి అవకాశం ఇవ్వాలి. విట్నెస్ని అడిగేదానికి, ఎదురు ప్రశ్నలు అడిగేదానికి మీకు అవకాశం ఇస్తే కానీ అది న్యాయమైన ఇది హియరింగ్ కాదు. దెన్ ఇంకొకటి ఏమంటే ఇది ఇప్పుడు సపోజ్ నేరం రుజువు అయింది అనుకోండి, నేరం రుజువు అయితే కోర్టు ఏం చేస్తారంటే, న్యాయస్థానం ఏం చేస్తారంటే మిమ్మల్ని శిక్షిస్తారన్నమాట. ఎస్, సపోజ్ ది అఫెన్స్ ఇస్ ప్రూవ్డ్ or established, the court convicts the accused for whatever period is mentioned. Suppose the court finds that there are no substance or the allegation made against you, the charge made against you is not proved beyond any shadow of doubt, then the court acquits the accused and the court releases the accused from custody. Then the question arises, suppose the court convicts the accused, శిక్ష పడిందంటే అప్పుడు కోర్ట్ కెన్ గివ్ యూ రైట్ ఆఫ్ ఫైలింగ్ అన్ అపీల్ బిఫోర్ ది సుపీరియర్ కోర్ట్ విత్ ఇన్ ద పీరియడ్ దట్ ఈస్ గ్రాంటెడ్ యూ. అండ్ దెన్ దాని మీదట మీరు హైకోర్టు పోయేదానికి కూడా అవకాశం ఉంది, సుప్రీంకోర్టు పోయేదానికి కూడా అవకాశం ఉంది. సపోజ్ మిమ్మల్ని వదిలేశారనుకోండి, అప్పుడు ఎవరైతే నేరం చేశారని చెప్పి అర్జీ పెడతాడో వానికి వ్యతిరేకంగా పోతే వాడు కూడా హైకోర్టు పోవచ్చు. కానీ ఒకటి గుర్తుపెట్టుకోవాలా, ఎప్పుడైతే యు ఆర్ గోయింగ్ ఇన్ అపీల్ అగేన్స్ట్ an acquittal, you have to high court before your appeal is numbered. So leave to file an appeal against acquittal is not a matter of right but subject to leave of the court. Then ఇక్కడ ఈ నేరాలు ఏదైతే ఉందో దాంట్లో ఎవరు కోర్టు అర్జీ పెడతారు, అది పోలీస్ స్టేట్ ఆఫ్ ఆంధ్రప్రదేశ్ ఆర్ స్టేట్ ఆఫ్ తెలంగాణ త్రూ పోలీస్ స్టేషన్ కార్ఖానా సికింద్రాబాద్ కంప్లైంట్ అని రాస్తారు. ఎవరి మీద అయితే నేరం మోపడం అయిందో వాని ముద్దాయి అంటారు, వాని పేరు, వాని అడ్రస్ అంతా రాస్తారు. ఇంకోటి ఛార్జ్ షీట్లో ఒకటి ఇంపార్టెంట్ ఇది ఏమంటే ముఖ్యమైనది, వాట్ ఈస్ ఇంపార్టెంట్ ఇన్ ద ఛార్జ్ షీట్ ఈస్ ఇన్ ది అనెక్షర్ ఇఫ్ you find a list of witnesses, complainant, then complainant's son, complainant's daughter, then eyewitnesses, punch witnesses, and other police IO, so on and so forth. So everything is ready-made for you. But the question is, in what serial they should be examined. Please remember, it's not necessary that you should examine them in the serial which is mentioned in the list of witnesses. The police can examine or take the permission of the court to examine the witnesses at any time or at a day fixed. Then question arises how the witness is brought to the court. Summons are issued to the witness to be present in the court on a particular day at a particular time, and his evidence of testimony is recorded. Then the question arises, sir, who serves the summons? It is a police officer, police constable of the concerned police station who serves the summons on the accused. Why? Because unlike civil court, you don't have the Nazarat section or the Amina section as they call it. It's a concerned police station, the concerned police officer who tries to serve the summons on the accused. Then ఇంకోటి సుప్రీం కోర్ట్ మన సుప్రీంకోర్టు ఏమన్నారంటే ఒక కేసులో ఎప్పుడైతే ఒకరిని అరెస్ట్ చేస్తారో ఏ గ్రౌండ్ మీద విచ్ గ్రౌండ్ ఈస్ బీయింగ్ అరెస్టెడ్, వాట్ ఆర్ ద గ్రౌండ్స్ విచ్ ఆర్ అలెజ్డ్ అగేన్స్ట్ హిమ్, what is the offense he has committed, he has got a right of knowing the grounds on which he is charged. వానికి గ్రౌండ్స్ చెప్పకుండా వాడిని అరెస్ట్ చేసేది అన్యాయం అని చెప్పి సుప్రీంకోర్టు 2024లో ఒక జడ్జ్మెంట్ ఇచ్చారు. సో accused should be made known as to what is the offense he has committed, what are the grounds on which he has been arrested, why he has been arrested, so on and so forth. So once the charge sheet is filed into court, it is numbered as CC. CC means calendar case. Then suppose police వాళ్ళు మీరు ఇచ్చిన అర్జీ మీద వాళ్ళు ఏ చర్యలు తీసుకోకపోతే మీరు ప్రైవేట్ కంప్లైంట్ వేయొచ్చు, సెక్షన్ 192 రెడ్ విత్ 200 CRPC. అప్పుడు వేసేటప్పుడు మీరు స్వోన్ స్టేట్మెంట్ కూడా ఫైల్ చేస్తారు. ఫైల్ చేసేటప్పుడు కోర్టు మిమ్మల్ని ఎగ్జామిన్ చేసేసి నిజంగానే మీకు కేసు ఉందా లేదా అని దాన్ని పరిశీలించి వాళ్ళు పోలీస్కి ఆదేశం ఇస్తారన్నమాట. ఈ మ్యాటర్ మీరు ఇన్వెస్టిగేట్ చేయండి, దీన్ని ఏం నిజమో అబద్ధమో చూడండి అని చెప్పి పోలీసు వాళ్లకు 157 under 157 the magistrate can refer the matter to the police for investigation, and the police officer to whom the matter is referred investigates the matter under 160, 172 and 173 CRPC and submits a report into the court called the IR, or what is called the investigation report under 174. Then ఇప్పుడు క్రిమినల్ లాలో ఈ క్రిమినల్ కేసెస్ how many types of cases are present? Summary trials, warrant cases, and sessions cases. Summary trials అనేది it is triable by a magistrate where the offense is punishable less than 2 years, and the fine that is to be imposed is not more than 5,000. Beyond 2 years, up to 7 years, it is the right of the assistant session judges who can try the matters. And in our twin cities, they are in Nampally, especially the criminal courts, they are called the chief metropolitan magistrate. Then above 7 years are punishable with death or life sentence. Then in that case, it is the sessions court which can alone try those cases. A court trying a summary case cannot try a case which is punishable more than 2 years. They have no powers. Then what is the procedure that is followed once the summons are issued to the accused and a preliminary referred case comes before the court, what is called PRC? Then in that case, previously we had committal proceedings, witnesses were examined, but now the court directly says it is triable by sessions and asks the accused to be present before the sessions court on a particular day at a particular time and then answer the charges that are made against him. The court cannot try that accused in that court because it has no jurisdiction. Then Then the question arises, sir, what is the difference between judicial custody and police custody? As far as judicial custody is concerned, the accused is given odd liberties in the prison and is subject to the supervision of the court from time to time, and he can relax himself. As far as police custody is concerned, he is completely in the hands of the police, who can investigate and interrogate him and record his statement. Then, first and foremost is, we have different witnesses. Before going to that, there is a document called Panchanama. Panchanama means where the offense has taken place, the police, under the supervision of the executive magistrate, goes to the spot, investigates the offense, and then he calls the panchas who witness that investigation, and they are asked to sign as panchas before whom the investigation takes place, or before whom the sketch is prepared, before whom the interrogation takes place. They are all called panchas or punch witnesses. And sometimes eyewitnesses, people who have actually witnessed the offense being committed, or people who are present at that particular time, are called eyewitnesses.
Sir, I have a question related to the panchas.
Tell me, sir.
Sir,
Sir,
panchas means
sir,
five persons.
and excuse me, sir, at the end of the session, I'll try to clarify. Sir, please bear with me. Please note down and ask me at the end of the session, please. Yes. Then, please remember, the question is, for a cross-examiner, it is important you concentrate on the eyewitnesses and the punch witnesses. Normally, the punch witnesses are witnesses who are stock witnesses for the police. Usually, a pushcart person who sells vegetables, or a pushcart person who sells fruits, or a pushcart person who has what is called chart bandi, so on and so forth, because they're always under the control of the police. And sometimes what happens is they are not present at the spot, but their signatures are taken later, and they are not present at the time when the investigation takes place. They are not present at the time when the sketch is prepared, so on and so forth. They are not proper. Concentrate yourself on the punch witnesses. One important thing a cross-examiner should know while cross-examining a witness is the eyesight of the witness, whether he is short-sighted or long-sighted, whether he can witness the offense from a particular angle, whether he has been actually present at that particular time, what was his duty hours at that time, what was his employment, whether he was really present or not present, or came after the offense has been committed, or he has not seen the offense at all, but he has heard it from someone. Please remember, under the Indian Evidence Act, hearsay evidence is not permissible. When you say that you have seen it, you must see it with your own eyes. If you say that you have heard it, you must hear it with your own ears. If you say that you have smelt it, you must smell it through your own nose. If you say that a particular poison has been administered on you, then you will have to say that it has been. That is, hearsay evidence is prohibited as far as Indian Evidence Act is concerned. Here, you must concentrate yourself on the punch witnesses and eyewitnesses. Don't give any importance to the complainant and the IO. But when you examine the IO, or cross-examine the IO, rather, I put it that way, you say, sir, what are you in the police station? What was your duty hours on the day when the offense has been committed? At what time the complaint was given? How did you investigate the matter? When did you record the statements of witnesses? And how did you file the charge sheet? On what basis you have come to the conclusion that the accused has committed the offense? These are all things which you have to ask the IO. But somewhere what happens, I'll tell you one instance, sir. In one of the cases, 9 accused were apprehended under 498A and 4 and 6 Dowry Prohibition Act. The IO I was the cross-examiner. I asked the IO, sir, what are your duty hours? And that she said, my duty hours are so and so. When he recorded the statement of the so-called eyewitness, how did you record it? She said, I have recorded it in writing. If you have recorded it in writing, where is the manuscript? Or if you have typed it, where did you type it? Did you type it at the spot, or did you type it in the police station? Where are the manuscripts? She says, I don't have the manuscripts with me. Then I said, who gave the statement? Sir, the advocate for the prosecution, the advocate for the complainant came to the police station. I asked the witness to stay out, and the advocate dictated the statement, and I recorded the statement. Please remember, all these things are immaterial because it's not. Whenever a statement is given, it should come from the horse's mouth, not from the mouth of an advocate. Advocate has no right to give a statement on behalf of his client. One more thing you must remember is in criminal cases, mostly inconsistencies, contradictions play a very important part. Wherever any inconsistencies have taken place, what has been given in the complaint, what is stated in the FIR, what is stated in the charge sheet, what is stated by the witness while being examined, all those things have to be examined. Wherever you find inconsistencies, contradictions, get those contradictions marked at the time of evidence itself so that you can always rely upon it and say, this witness, the statement of this witness is not trustworthy, it cannot be believed at all. So, in criminal cases, mostly we succeed on a particular case on the basis of the contradictions, admissions, and the inconsistencies in the evidence as well as the complaint or the FIR that has been lodged. One more thing you must bear it in mind is uh, don't go, and please remember, presence of mind in a criminal case is absolutely essential. Don't absent yourself when the witness is being examined. Sometimes what happens is the prosecution leads the witness and the witness speaks according to what the prosecutor asks. In that case, you can always object and say, sir, answers cannot be put into the mouth of the witness and the witness cannot be examined in that particular way. And suppose an objectionable document is filed, you must have an opportunity of contradicting it and saying that this document is not admissible at all. Then one more thing you must remember is the question is mostly witnesses come for a song. The witnesses who are there are all interested witnesses. Don't expect the witnesses of the prosecution to help you in cross-examination. By your own cleverness or by your own skill, you have to get some positive answers. One more important thing you must remember is that first, before you do the cross-examination or commence the cross-examination, put some pleasant questions to the witness. Lead the witness to a sense of complacency. After the cross-examination is nothing but he can face it. But when the time comes, you put the relevant questions and then get the answers. And when you get a positive answer, don't come to that question again because you'll be giving an opportunity to the witness to correct himself. Because when you cross-examine in civil matters, here there are four types of witnesses. One is a truthful witness, another is a 50-50 witness, another is a witness who has come only to speak falsehood, one is a witness who has come only to test the knowledge of the cross-examiner, so on and so forth, or another witness who does not know anything but pretends as if he knows everything. So study the psyche of the witness by putting some simple questions and bring him to a sense of complacency and try to achieve your object. Please remember, that is why it is said in criminal cross-examination, you shall not cross the Lakshmana Rekha, as it is called. You shall not cross the offending line because sometimes you try to prove or establish what the prosecution has not proved. Don't address yourself to the audience. Please don't try to translate the cinematic actions into practice because cinematic or what you see in TV is something different than what goes on in court. And here, what happens is be very careful when your statements are being recorded, when your answers are being recorded. Try to go through the 161 statement, try to go through the complaint, try to go through the FIR, try to go through the various aspects as far as evidence is concerned. Try to prove or establish a particular your particular defense. Here, sometimes what happens is, suppose let us say a person is accused of causing injuries to a person with a knife. So, by your clever cross-examination, you can say, sir, these particular injuries can occur even by falling on the ground and where there are scratches or lacerations on the body. It is not through a knife or it's not through any other thing. It can be by a stone also. Falling against a stone also, such injury can be caused. Then, especially in forensic cases, also you can say the extent of injury, how the injury is caused, which type of weapon can cause that injury, whether a knife can cause an injury, whether a stone can cause an injury, falling on the ground can cause an injury. You cross-examine, and based on the forensic report, you try to find out what are the lapses committed with the forensic surgeon by conducting autopsy or post-mortem. These are all the basic things which you cannot read from the book. These are all things which must be innate in your mind, and you must all presence of mind, and don't try to prove or establish what the prosecution has not proved, because sometimes it's disastrous. And don't go for lengthy cross-examination. Prepare a case well beforehand. After all, the advantage which you get in criminal matters is everything is ready-made for you. You got the complaint, you got the FIR, you got the 161 statements, you have got the documents which are filed by the prosecution. Only thing is you have to use your brain. So don't try to lend your brain to someone. Use your own brains and prepare your case, and prepare it well beforehand. And as far as possible, it is advisable in a criminal case, don't go for lengthy cross-examination. Why? Because you land yourself in trouble. Yes, this is as far as today's lecture is concerned. We go to the interaction, please. Any questions, please? Someone asked me a question. I said, after the session, you kindly ask.
So cross-examination around medical officer, revenue officer, forensics, punch witness.
Yes.
Mr. Venkat.
Mr. Venkat, as far as the police witness is concerned, don't concentrate much on that particular aspect. You say what was your duty hours, what are you in the concerned police station, what is your designation. This particular offence is only triable by the DCP. For example, cyber offences which are there, they have to be tried. The statements have to be recorded, and investigation has to be done only by a person not less than DCP SCADA. And as far as the medical officer is concerned, you try to test his knowledge, try to test his experience, and try to test his basis on which he has come to a particular conclusion. And as far as revenue official is concerned, you just ask him a question. Please remember, so many things take place in the revenue office. Try to say, what's your experience? What were you at the time when the statement, at the time when you made the entries in the revenue records? Are you the concerned officer? On what basis or what documents you have recorded these statements? Please try to give an explanation.
Sir, my question, sir, Naveen Kumar, sir.
Yes.
Sir, my question is, especially in the 498 case,
yeah,
date of offense happened 1 month before.
Yes.
But she lodged a complaint 1 month after.
Yeah.
So is it valuable, sir? The FIR is valuable?
As far as 498-day cases are concerned, there is no limitation, please.
No limitation.
No limitation. In this regard, I just try to take you to one of the lectures of Justice B.S.A. Swami as it then was. He said, compared 498A to 304B, 304B. He says, as far as 304B is concerned, it's an amendment that was brought about where they say 7 years after the date of marriage, so within 7 years from the date of marriage, if the bride dies, it is presumed that's a dowry death. The burden is on the accused to show that it's not a dowry death, it is out of natural circumstances she has died, and I have never committed that particular offense. But 498A, most of the 498 cases are all tutored cases. Unfortunately, when we see the cases before the court, the sister-in-law, the brother-in-law, brother's child, so on and so forth, they're all brought before the court concerned and asked to face a trial. But the Supreme Court has clearly clarified only the mother of the husband and the husband himself are liable. And as far as others are concerned, you cannot implicate them in a case of 498A. And most of the 498A cases fail because of their being tutored and they're being brought about in order to harass the husband. And most of the 498A cases, you must go on technical defenses and not on the actual law. Yes. There is no limitation for 498A, please. Naveen Kumar.
Any questions, sir? Anybody?
Sir, 65 in evidence, secondary evidence.
Yesterday you asked that question. That is secondary evidence in civil law. That is in evidence. I'm sorry. In evidence,
it is not possible, sir.
In evidence, here, as far as criminal law is concerned, Please remember, Indian Evidence Act is common to civil and criminal. What applies to civil also applies to criminal, because Indian Evidence Act, you don't have Civil Evidence Act and Criminal Evidence Act. The Evidence Act is common to both. So whatever applies to Evidence Act, civil matters, also applies to criminal matters, more particularly Section 65.
What is the right time to submit successful petition between the cross-examination? Can we ask that also? And after the
You can
cross-examination,
always file the petition and saying that original is lost, destroyed, damaged, or mutilated, are not in my custody, but is in the custody of the opposite side. Please permit me to file the certified copies or the Xerox copies duly certified with my self-attestation. That is 65B to be proper. Under the IT Act, it is Information Technology Act. It is applicable.
Sir, you said that 313 examination after.
So I'm sorry, I've entirely forgot about it, sir. 313 examination is, suppose the trial is over, evidences are recorded, then the court, based on the evidence that is on hand, based on the evidence, he says this particular witness has spoken in this particular way. What do you say? Then the accused says, sir, I have not committed it. The statement given by him is false and incorrect. Then various questions will be put where the accused is examined under 330. Then the accused is given one more opportunity of leading his defense evidence. Where if he has got witnesses, he can also put the witnesses into the witness box. They are called defense witnesses. And the accused himself can go into the witness box and give a statement, and the statement will be recorded subject to cross-examination by the prosecutor. And sometimes what happens is, suppose the prosecution witness turns hostile against the prosecution has got a right of cross-examining that particular witness to discredit him and say that he has been won over or procured by the opposite side. 313 statement, the importance is the accused is asked about the statement made against him in the evidence, and then asked to admit or deny it. I mean, making myself clear to you, please. Next.
Venkata Satyanarayana garu. Sir, please unmute your mic, sir.
Hello.
Yes, sir. Please go ahead.
Sir, good evening, sir. Sir, and the GPA.
Yeah.
And sir, there is no witness signature. Is valid?
Pardon, sir?
Valid అవుతుందా?
దేనికోసం?
GPA లో వచ్చేసి GPA త్రూ యాక్చువల్ ఎన్ఆర్ఐకి GPA ద్వారా తను అపాయింట్ చేసినట్టుగా చూపిస్తున్నారు. దాంట్లో ఫ్యూచర్ లేదు. స్టాంప్ పేపర్ మీద అయితే చేశారు.
GPA అనేది ఒక కాంట్రవర్షియల్ డాక్యుమెంట్ అండి. GPA ఫర్ ఆల్ పర్పసెస్ ఇట్ కెన్ బి గివెన్, బట్ ప్రాపర్టీ ఉన్నప్పుడు అది రిజిస్టర్ కావాలి. రిజిస్టర్ కాకపోతే అది చెల్లదు కోర్టులో. అది ఏమంటారంటే సార్, ఇట్స్ బ్రాంచ్ ఆఫ్ లా ఆఫ్ ఏజెన్సీ అండి. దట్ ఈస్ యూ డోంట్ యాక్ట్ ఆన్ యువర్ ఓన్, బట్ యూ యాక్ట్ టు సమ్ అదర్ పర్సన్ హూ ఇస్ యువర్ ఏజెంట్, and that agent has got as much power to act on your behalf so long as the power given to him is in existence. Normally ఒకటి ఒక వర్డ్ రాస్తున్నారు, irrevocable general power of attorney రాస్తున్నారు. irrevocable general power of attorney అనేది ఏది శాశ్వతం కాదు. ఎప్పుడైతే మీరు నష్టం చేస్తారో అప్పుడు ఎప్పుడైనా క్యాన్సిల్ కూడా చేయొచ్చు. అండ్ గోయింగ్ ఫర్దర్, ఎస్
ఓకే సార్, అది
ఇంకోటి చెప్తానండి. దీంట్లో మీరు పవర్ ఆఫ్ అటార్నీ అడిగారు కాబట్టి 202 ఆఫ్ ది కాంట్రాక్ట్స్ యాక్ట్ కింద ఏజెన్సీ బై నెసెసిటీ అనేది ఉంది. దాంట్లో ఎలాగంటే, సపోజ్ ప్రిన్సిపల్ ఎవరైతే పవర్ ఇస్తాడో ఆయన చనిపోయాడు అనుకోండి, సపోజ్ ఈ డైస్, ది పవర్ ఆఫ్ అటార్నీ డస్ నాట్ డై ఇఫ్ ఎనీ ది ఏజెంట్ అక్వైర్స్ ఎ రైట్ ఓవర్ ది ఇమ్మూవబుల్ ప్రాపర్టీ. ఫర్ ఎగ్జాంపుల్, మీరు డెవలప్మెంట్కి ఇచ్చినప్పుడు 60-40 అంటారు. పవర్ ఆఫ్ అటార్నీ హోల్డర్కి 60%, మీకు 40% అని. వాడి ప్రిన్సిపల్ ఎవరైతే రాసి ఇచ్చాడో వాడు చనిపోయినా కూడా వీడి పవర్ పోదు. దట్ ఇస్ కాల్డ్ ఏజెన్సీ బై నెసెసిటీ సార్. దట్ ఇస్ 202 to 217 కాంట్రాక్ట్స్ యాక్ట్.
Yes, sir.
నా మెయిన్ క్వశ్చన్
Sir.
Yes.
So 313 examination law, you said that court given opportunity for accuser after examination.
Yes.
Any defenses are there, he can produce the defenses. It is
Exactly.
better to produce or not to produce.
It is his own choice, sir, whether he wants to produce or
I
doesn't.
mean, as per your concern, accuser evidence పెడితే మంచిదా, otherwise better court.
But suppose he has got some concrete points against the prosecution, it is better to examine defense witnesses.
Sir, especially in examinations law, the few of the advocates, they insulting the witnesses.
Yes.
Then we have anything to compel them because don't do like that. చెప్పడానికి
Sir, normally, sir, ఇప్పుడు ఎట్లయిపోయిందంటే అదే చెప్పాను నిన్న లెక్చర్లో చెప్పేటప్పుడు కూడా డోంట్ ఇన్సల్ట్ ఎ విట్నెస్, డోంట్ అనాయ్ ఎ విట్నెస్, డోంట్ ఇంటిమిడేట్ ఎ విట్నెస్, డోంట్ థ్రెటన్ ఎ విట్నెస్, డోంట్ యూస్ హార్ష్ లాంగ్వేజ్ అగేన్స్ ఎ విట్నెస్. బట్ అది పాటించే మీదతో ఉంది. న్యాయమూర్తి గారు ఎవరైతే ఉన్నారో ఆయన చెప్పాలి, ఇటువంటి ప్రశ్నలు మీరు అడగమాకండి, వాడిని అవమానపరిచేదానికి మీకు ఏం హక్కు లేదు, నెక్స్ట్ టైం ఇది అడిగితే నేను అది మిమ్మల్ని పర్మిట్ చేయనని చెప్పి జడ్జి గారు చెప్పాలి. జడ్జి స్ట్రాంగ్ ఉండాలి. కానీ అన్ఫార్చునేట్లీ ఈ రోజుల్లో జడ్జి గారు స్ట్రాంగ్ లేరండి. బికాస్ ల్యాక్ ఆఫ్ ట్రైనింగ్. క్రిమినల్ మిస్లేనియస్ పిటిషన్.
సురేఖ గారు.
Yes. Criminal miscellaneous petition means it is called CRLMP. That is anything that is filed which is not provided during the pendency of a main case is called a miscellaneous petition, and in short it is called a criminal miscellaneous petition or CRLMP. Like in civil law we file what is called IA, interlocutory application. It's an interlocutory application. On a criminal side is called criminal miscellaneous petitions. And all bail petitions, etc., are production of records, and all are in the form of criminal miscellaneous petitions. And please remember one thing: like civil law, we don't have a petition and affidavit. You need not file an affidavit in a criminal court. Mere petition is enough. In a third person, you can mention it in the form of a petition. No affidavit is necessary in a criminal court. And any miscellaneous application which is filed, like bail petition, production of records, or recall of a witness, then you want a particular further cross-examination, those provisions which are mentioned, or you want to lead defense evidence, all those petitions which you filed during the, or recall of NBW which has been issued by the court, or recall of the remand order, or bail petitions, etc., etc., those petitions which are filed are called criminal miscellaneous petitions. They are not CCs. CCs means calendar case. Anything that is filed during in a pending case is called a miscellaneous petition. If it's civil, it is civil miscellaneous. You see, in civil it is IA, and in criminal it is CRLMP. Yes.
సార్ క్రాస్ ఎగ్జామినేషన్ చేస్తూ మనము మధ్యలో మనం ఈ సిడీస్ ఎట్లా ప్లే చేయాలి సార్? క్రాస్ ఎగ్జామినేషన్ చేస్తూ విట్నెస్ ని చేసేటప్పుడు మనము ఈ పెన్ డ్రైవ్ గానీ ఈ సిడీస్ గానీ ప్లే చేస్తాం కదా సార్?
See, pen drives are normally not allowed, sir. But CDs you can always take it in the chambers and play it before the judge, not in the open court.
అంటే between the examination play చేయొచ్చు సార్ అది?
You can play, but you have to take the permission of the court.
Okay.
Because here you have to guard against ventriloquism, as they call it. Suppose you are there, I imitate your voice and talk like it, just doesn't mean that Naveen Kumar has talked something that someone was imitated your voice. That is a famous case of Nagarwala's case, the Supreme Court case of Indira Gandhi.
I mean, I'm asking a special 65B petition. In
65B,
why voluntarily she went out, sir?
As far as 65B is concerned, it has come into play after the Information Technology Act has come. It says that once you produce a document by way of secondary evidence, it should be self-certification, saying that it has been taken from a computer where the data is still available to you, and you give the date on which you have taken, the time at which you have taken, and you also say you are prepared to produce the original data into court to substantiate what you have filed into the court. That is what is called 65B.
Yes, sir. అది పర్ఫెక్ట్గా ఉన్నప్పుడు మనం ఎట్లా అది ప్లే చేయాలి?
ఏది ప్లే చేసేది?
See.
ఈ 65B data అంతా కంప్యూటర్
Then
నుంచి
in that
మనం
case, you take the permission of the court and play it in the chambers of the judge, not in the open court.
ఓకే సార్ 202 CRPC గురించి కొంచెం వివరంగా చెప్తారా సార్? అది ఏంటి? ఎఫ్ఐఆర్ బై పోలీసులు కదా సార్?
202 is no sir, 202 not 202 sir, 302 I was dealing with. I said if you want to assist the prosecution in conducting the prosecution, you want to help the prosecutor, you take the permission under 302 CRPC. 202 is what is called protest petition, what you are asking. That is, suppose they say police return the IR and say it's a civil dispute and nothing is made out, then in that case you can protest against the police report and tell the court, sir, police has not properly investigated the matter. Please send the matter back to the police, ask them to reinvestigate the matter and file a report. That is called protest petition under 202.
Okay, దాని తర్వాత కూడా if they not taken action,
then go to the High Court against that dismissal or Sessions Court, saying that the lower court has improperly rejected it.
Is there any more questions? Shall we continue or tomorrow? Yes, sir. Good evening, one and all. With today's session, yes, sir.
Hello, madam. Good evening, madam.
Yes, Swami garu cheppandi.
304A లో
Sir.
ఇటువంటి కేసుల్లో
Yes, sir,
ఒకసారి
please.
హాస్టల్ విట్నెస్ అయినాక
Sir, please be a bit loud.
Sir, Swami garu కొంచెం పెద్దగా మాట్లాడండి. You are not perfectly audible.
ఓకే మేడం. 304A యాక్సిడెంట్ కేసులో మేడం
304A na B? A is rash and negligent driving.
ఓకే సార్.
Yes.
అయితే అందులో ఐ విట్నెస్ ఒకసారి హాస్టల్ అయిపోయినాక
Sir.
ఐఓ ఎవిడెన్స్ పైన కానీ ఏమైనా కన్విక్షన్ ఇవ్వచ్చు.
Conviction ఇవ్వలేరండి. Eyewitness has to speak the truth. If he doesn't speak the truth or his evidence is inconsistent or contradictory, court can reject his evidence. And if any other eyewitness is there, it can definitely be considered. No one says no.
ఓకే సార్.
ప్రశాంత్ గారు అడుగుతున్నారు సార్, ఎవిక్షన్ సూట్ లిమిటేషన్ గురించి అడుగుతున్నారు. ఎవిక్షన్ సూట్ లిమిటేషన్ గురించి అడుగుతున్నారు ప్రశాంత్ సార్.
See, as far as your question is concerned regarding eviction suit, we have got two laws called general law and special law. Special law is the Rent Control Act, and general law is what is called the Transfer of Property Act. Transfer of Property Act section 105 to 112 or 114 deals with the eviction suits, a law of leases. In that, what all is required is, if it's a monthly tenancy, 15 days notice has to be given, terminating with the last date of monthly tenancy and asking the person to vacate on the next day. But as far as limitation is concerned, there is absolutely no limitation. I think you're perhaps trying to confuse your question. Suppose a lease is for 10 years. During that period of 10 years, you cannot get rid of a tenant. But suppose there's a clause there, notwithstanding anything contained in this document, if the lessee commits a default for at least 3 consecutive months, he is immediately liable to be evicted. But here, as far as TP Act is concerned, or your eviction suits are concerned, there is no limitation at all, please.
Any more questions, sir? Anybody? Okay, sir. From this session, we are completed with the art of cross-examination in civil and criminal matters. So, from tomorrow onwards, we are going to conduct CPC classes for 30 days, sir. Sir, please.
Same time, madam.
Same time, sir. Same time, 7 to 8 o'clock. Tomorrow we are starting with introduction of CPC and 30 days. It's a 30 days program. Sir will explain it in detail.
Madam, thank you, madam. My name is Purlana, advocate Anantapur, madam.
Okay, sir. Namaste, sir.
This session is super, madam. excellent explanation to the సార్ చాలా చక్కగా చెప్పాడు మేడం. మేము ఇట్లాంటి వాళ్ళ దగ్గర తర్ఫీ చేసుకొని ఉంటే చాలా ముందుగా ఉండేవాళ్ళని.
Thank you, sir. Thank you so much. So, to utilize this opportunity, we are conducting, sir. Please utilize this opportunity, sir.
Okay, thank you.
నేను ఆల్రెడీ నిన్న కూడా సార్ గురించి ఇంట్రడక్షన్ ఇచ్చాను. 52 years ఎక్స్పీరియన్స్ ఉంది సార్కి, ప్రాక్టికల్ ఎక్స్పీరియన్స్. ఇంకా స్టిల్ హీఈస్ ప్రాక్టీసింగ్ ఇన్ సికింద్రాబాద్ కోర్ట్. సో ఈయన 28 years ఆఫ్ టీచింగ్ ఎక్స్పీరియన్స్ ఉంది సార్. లెక్చరర్గా పనిచేశారు ఓయూలో. ఐఏఎస్లకు కానీ ఐపీఎస్లకు కానీ వాళ్ళకి కావాల్సిన క్లాసెస్ తీసుకున్నారు. జ్యుడిషియల్ అకాడమీలో సార్ క్లాసెస్ తీసుకున్నారు. చాలామంది జడ్జెస్కి సార్ బాగా తెలుసు. సార్ దగ్గర కోచింగ్ తీసుకున్న వాళ్ళు కానీ, చదువుకున్న వాళ్ళు కానీ, జూనియర్స్ కానీ ఇప్పుడు మంచి మంచి పొజిషన్లో ఉన్నారు సార్. వీఆర్ వెరీ ప్రివిలేజ్ టు హ్యావ్ him as our senior. Me and my brother are very close associates of sir. So please, I just want to conclude by saying that please utilize this opportunity. From tomorrow onwards, we are going to conduct classes on only CPC. Sir will cover everything in CPC which are interlinked to CPC. Those are like specific relief act, contracts act, anything which is related to that particular aspect, he will going to cover everything in a large manner, sir. So kindly utilize this opportunity, sir.
Thank you, madam. Thank you, madam. Jai Gurudatta, madam.
Right, sir. Jai Gurudatta. Sir.
Venkat garu is asking before what the stage of protection.
One second. I'll check, sir. Chat box lo bettara question.
Before the stage, what the protection can be, sir? Protection petition can be done. What's the
not protection, protest petition.
Madam, please, sir, mobile number.
Sir, గ్రూప్ లో ఉంది సార్, ఒకసారి చూడండి. డిస్క్రిప్షన్ లో కూడా ఉంది. మొబైల్ నెంబర్ మేము ప్రొవైడ్ చేసాము. ప్లీజ్ గో త్రూ. మొబైల్ నెంబర్ కూడా మేము ప్రొవైడ్ చేసాం సార్.
Okay, thank you. 157 కదా last.
Yes sir. And one thing, నాకు ఇక్కడ ఉన్న క్వశ్చన్ అయితే కనిపించడం లేదు. Yes.
Anyhow, I try to answer that question. Protest petition can be filed once the IR is filed by the police under 174 CRPC, where there are discrepancies in the police report. Police has not interrogated properly, investigated properly. There are a lot of loopholes. There are a lot of inconsistencies, contradictions, etc. This can be highlighted in your protest petition and to satisfy the court to resend it back for reinvestigation. That's what is the scope of 202 CRPC. And if the court does not accept your protest petition, you are always free to file the necessary papers before the superior court and get it agitated there. Either file an appeal or revision, which has been provided under CRPC.
Yes, sir. Yes, Prashant Garu, I hope your doubt was cleared. Okay, sir. Any more questions, or shall we conclude this session? Other topics. ఎస్తర్ గారు, ఆ పర్టికులర్ సెక్షన్ చెప్పేటప్పుడు ఏ క్వశ్చన్స్ లేకపోతే ఏ ప్రొవిజన్స్ వేరే యాక్ట్లో దీనికి రిలేటెడ్ అవుతాయో, ఇంటర్లింక్ చేసుకోవచ్చో, ఆ పర్టికులర్ సెక్షన్స్ మీద, ఆ పర్టికులర్ యాక్ట్ మీద కూడా సార్ ఇంటర్లింక్ చేసి చెప్తారు. ఈ పర్టికులర్ స్టేజ్లో ఏంటి, ఏ యాక్ట్స్ కవర్ చేస్తారు అనేది మేము కూడా చెప్పలేము. సో ఎనీ మోర్ క్వశ్చన్స్?
సత్యనారాయణ గారు నిన్న ఏదో క్వశ్చన్ అడిగారు మేము.
GPA without witness signatures, can it valid as principal is NRI?
As far as GPA without witness is concerned, it's unenforceable. It cannot be looked into at all. Witnesses attestation is absolutely essential. You cannot dispense with attestation as far as the GPA is concerned. more particularly when the executed is an NRI.
Hope you are cleared with your doubts, Satyanarayana Garu.
Madam, in a 302 IPC, like a heinous crime, does it require the counsel is did not want to go with the other counsel? Can he change without taking NOC?
In criminal matters, there is no question of NOC, sir. At any time, it can at any time the new advocate can come on record.
Okay, thank you so much, sir.
Right, somebody is asking about Panchanama.
As far as Panchanama is concerned, it's also called what is called an inquest. That is, whenever a crime has been committed, when the police goes to the spot with the help of the executive magistrate, they are asked to witness what the police has done, what are the steps they have taken, whether they have noted the place of offence, and whether they have prepared a sketch. What are the probable reasons why the accident has occurred or something has occurred, in what circumstances it has been done. But the punch is expected not to know about it. But the Panchanama is written by the police concerned, and then the signatures of the witnesses that the Panchanama was done in their presences. They do not have the knowledge of the facts that are mentioned in the Panchanama. He only says, police వాళ్ళు సంతకం పెట్టమన్నారంటే సంతకం పెట్టండి. దీంట్లో ఏం రాసిందని చెప్పగలరంటే చెప్పలేను అంటాడు. They are all stock witnesses of the police case. So the efficacy or the importance of Panchanama is things have been done in the proper way and in proper manner. That's all. But it is not conclusive proof regarding what has happened and what should have happened or what has really happened at this point.
Injunction order in civil court, sir.
Sir, I will deal with this when I come to CPC, sir. That is order 39. When I come to order 39, I'll also deal with 37, 38, 39 of the specific relief act, which speaks about.
Sir, 1 minute, sir. ఇక్కడ క్వశ్చన్ ఏంటంటే ఇంజంక్షన్ ఆర్డర్ సివిల్ కోర్ట్ లోనే ఇస్తారా, హైకోర్టు నుంచి కూడా తీసుకోవచ్చా? బ్యాంక్ పేమెంట్స్ చేయనప్పుడు లైక్ క్రెడిట్ కార్డ్స్ అండ్ ఈఎంఐస్ దగ్గర నుంచి షల్ బి టేక్ ఇంజంక్షన్ ఆర్డర్ అని అడుగుతున్నారు.
As far as injunction is concerned, it should be taken only from the civil court. High court has no original jurisdiction. Like presidency terms, High Court has no original jurisdiction. You have to go only to the lower court. Injunction can be granted only by civil courts, not by High Court.
Yes, Kayum Pasha garu cheppandi. Please little bit louder, sir.
And దాంట్లో ఉన్నటువంటి కాంటెక్స్ట్ తెలుసు చెప్పడం తప్ప వేరే ఏ క్వశ్చన్ అడిగినా కూడా
recording stopped.
Please be a bit loud, sir.
Kayum Pasha garu, we are unable to hear your voice clearly. Please little bit loud.
Sorry, brother. Sir.
Naveen Kumar garu, please mute yourself. Kayum Pasha garu is asking question.
సివిల్ సూట్ లో క్రాస్ ఎగ్జామిన్ చేసే టైంలో విట్నెసెస్ కి సంబంధించినటువంటి సివిల్ సూట్ లో వాళ్ళ ఎవిడెన్స్ వాళ్ళు వేసిన తర్వాత ఆ ఎవిడెన్స్ సంబంధించి ఆయన ఓన్లీ ఆ డాక్యుమెంట్ నుండి కాంటెంట్ తెలుసు అంటాడు కానీ అందులో సంబంధించిన క్వశ్చన్స్ అడిగితే నో ఆన్సరింగ్ సార్.
See, sir, if he admits the signature, the question's contents are presumed. You need not go through the contents.
ఇంకోటి సార్, మనం క్రాస్ ఎగ్జామిన్ చేసే టైంలో అతను నో ఇవ్వట్లేదు సార్.
No report, the witness refuses to answer about the contents and record చేయించండి. Demeanor అన్నారు. Yesterday I referred to demeanor, that the mood of the witness or the character of the witness who appears, who does not answer itself means if he answers, it will go against him. That's the reason why he has not answered. You can ask the court to draw an adverse inference.
Right, section alteration గురించి గణేష్ గారు అడుగుతున్నారు. Section alteration in criminal procedure, sir.
Section alteration, please remember, we are not we are not operating trapdoors. The court can itself correct the section and then apply the correct section as far as that offence is concerned.
What are the main grounds for Panchanama report?
The main grounds for Panchanama report is the investigation that takes place, interrogation that takes place, the sketch that is prepared, the map that is prepared, who are examined, and these people who are present at that particular spot, they sign it saying that they have witnessed all these things happening, and they countersigned it to say that this has happened in their presence. That's only the effect of Panchanama, please.
Sir, please, tomorrow you are taking topic of CRPC of non-payments of banks. 164 confession statements, sir.
As far as 164 statements are concerned, it is recorded by a magistrate, and the person who is being examined will be forewarned, saying that you are not under a duty to speak. If you are going to speak, it is going to go against you. Please think better better before you give your statement. You are not under a threat. You are not under a promise. You are not under an inducement. He is given time to ponder over, think about it, and give a statement, which is not there in 161 and 162 police when police records. 164 is more transparent and more legal than others. It is recorded by a magistrate.
Yes, Rahman's Garu. Please unmute your mic, sir. Rahman's Garu. Yes, please.
Sir, suggestion, sir.
Yes.
Actually, today our topic is art of cross-examination in criminal and CPC.
No.
But మీరు entire your section లో complete definitions and meanings.
Sir,
and,
I told
sections
you
were
in
discussed.
the while going through the definitions itself, I said what all you are supposed to do, what all you are supposed to ask, how you have to begin your cross-examination, how you have to start your cross-examination, what should be your attitude when you cross-examine. You must study the various aspects of law, ingredients of that particular section, whether they are satisfied or not. Try to test the eyesight of
These things are not covered, sir. These things are you not said.
I will.
How to start or where to start.
It is
And
still,
better you take any kind of instances and if you explain
yeah,
better.
I will. I just spilled over to tomorrow, sir, for 15 minutes. I'll try to clarify that, sir.
Thank you, sir. Thank you, sir.
Welcome.
Right, sir. Right, we'll see you tomorrow, same time. Please, madam, read my question. Sir, banks గురించి రికవరీ ఏజెంట్స్ గురించి సార్ సిపిసిలో కవర్ చేస్తారు సార్. డెఫినెట్గా ప్లీజ్ ఫాలో ద క్లాసెస్. హీ విల్ డెఫినెట్లీ గివ్ solution to your questions.
Sir, one more question, sir. Navin Kumar, sir.
Yes. Yes, sir.
Can we change IO, sir? Can we change IO because it's not doing the investigation properly? Can we place any kind of petition before the honorable court and for proceeding to change the IO?
You have to go to the High Court only, sir. Lower court has no power.
Lower court has no power.
No.
Under which section, sir? That is?
That is under the inherent powers of the High Court under 482 CRPC.
Thank you. Thank you.